Law Weekly today features the opinions of some lawyers on the call by the chairman of INEC, Professor Mahmood Yakubu, for the establishment of the Electoral Offences Commission or Tribunal to try electoral offenders. We also have a recap of the top legal stories. And in our interview segment, we chat with a professor of law, Fidelis Odita. Professor Odita practices at the Nigerian and English bars in a broad range of areas. In this interview, we talk about the judgments of the court on election petitions, the criticisms trailing the judiciary, and the war against corruption. That's our lineup on this edition of Law Weekly. Hello and welcome to the program. I am Shola Shoyeli. The chairman of the Independent National Electoral Commission, INEC, Professor Mahmood Yakubu, has called for the establishment of the Electoral Offences Commission or Tribunal. He said that until this is put in place, the country will continue to record violence during elections. Now, it's not the first time that such a call has been made, but against the background of some recent allegations and revelations of rigging, particularly in Ekiti State, is there a need for such a tribunal? Who should prosecute electoral offences? And does the law require an amendment to the Electoral Act or the Constitution? These were some of the questions that I put to some lawyers who weighed in on the issue.
Why do we need tribunal? The judges who are dispensing justices in our courts, we've talked about delay, which people believe is affecting foreign investments in Nigeria, will now be saddled with responsibility again to go and sit at Election Malpractices Tribunal. We have judges who are sitting on EFCC cases. We have judges who are trying ICPC cases. We have those who are doing counterfeiting and fake drug cases. And then you have a judge who probably have 1,000 cases in his or her docket. And everybody wants justice in Nigeria in accordance with America or UK. These people are not, they don't use steroid and they're not machines. Honestly, our judges are already, I think, to put it mildly, saddled with more than enough responsibilities that a human being, not being a superhuman being, can handle. If there are electoral offenses, the security agencies should do their work. INEC should make sure that the offenses are not committed in the first place. And if they are committed, the police and all other security agencies should deal with the cases.
If we have institutions created to punish offenders, offenses are offenses. Whether it is offenses committed in the course of elections, or in the course of driving, or in the course of hitting, or anything, offenses are offenses, and offenders will remain offenders. If there are existing law that say, oh, don't do this, if you do it, you will face the wrath of the law, then there is no basis for us to be thinking of creating a specialized offices to try those offenders. You understand? So all we need to do is just to strengthen our political will to address these issues.
When an offense has been committed against an electoral law, it is basic that one thing must be done. You must make a formal complaint. Maybe people were arrested and all that. All you need to do is make a formal complaint to the police. You let the police investigate. Upon investigation, when the person is indicted, the person will be taken to the appropriate court. The appropriate court in this wise is a magistrate court. Now, it has been touted over time that, well, it seems as if whoever is taken before the police and subsequently we don't get to hear anything about it. That has been making people have this call to say, well, in this dispensation, do we need to continue with the regular magistrate courts on this matter? But I want to also, be on the side of the people calling for specialized courts. When people are, arrested or indicted for electoral offenses, what you need to do is have courts that will have speedy trial of such people so that it will serve as a deterrent for others.
But if there's a political will to fight corruption, to stand still, and they make the public office disinterested, and it's occupied by really people who really have or really want to work, I believe we would have started tackling the problem from that end. And then, because I do not see people are saying create a special court for this. We have had courts. For example, we have the court at the federal level. We have the court at the state level, at the high court. Even at the federal, we have national industrial court. We have all this. We have the laws. Those laws, to me, as far as I'm concerned, without fear of being contradicted, are enough. All you need to do is to train the personnel, create an enabling environment for the people who will do the job to do it clearly, efficiently. That's what I mean, efficient. Once that is done, I do not think there should be any other problem.
Lawyers appear to be divided on the issue of creating a special commission to try electoral offences, but they are unanimous that the country needs to move against such offenders, and quickly too. On to other issues, the courts have been very busy as usual. Here's a recap of some of the top stories we tracked.
We begin with the reports that the Supreme Court last week Thursday affirmed the election of Mr. Dairo Sishaku of the People's Democratic Party as a duly elected governor of Taraba State. In a unanimous judgment, a 7-man panel of the court upheld Governor Ishaku's election after dismissing the appeal filed against him by Mrs. Aisha Al-Hassan, the candidate of the All Progressives Congress (APC) in the April 11, 2015 poll.
But we don't know the reasons the Supreme Court is going to give.
Justice Bode Rhodes Favor, who read the summary of the lead judgment, held that Al-Hassan's appeal lacked merit as the nomination of candidates by the PDP to stand election was an internal affair of the political party. A 5-man panel of the appeal court judges, presided over by Justice Jummai Sankey sitting in Yola, last week Tuesday, nullified the impeachment of former governor of Adamawa State, Murtala Nyako. In a judgment delivered by Justice Tunde Ewoleye, the court set aside an earlier ruling of a lower court that upheld the impeachment. All the 5 judges unanimously ruled that the Adamawa State House of Assembly flagrantly abused tenets of law by infringing upon the fundamental rights of Nyako by removing him from office illegally. A Federal Capital Territory High Court in Maitama, Abuja, last week Monday dismissed an application by the immediate past National Security Advisor, retired Colonel Sambo Dasuki, seeking to stop his trial on the charges of diversion of 32 billion naira arms fund. Justice Hussaini Baba held that contrary to Colonel Dasuki's allegation, the Economic and Financial Crimes Commission was not in contempt of its order granting him bail on December 18, 2015. Dasuki was rearrested by the operatives of DSS on December 29, 2015, shortly after he met the bail conditions and was released from Kuje prison. Through an application filed before the court, he sought to prohibit the EFCC from prosecuting him over an alleged brazen disobedience of the orders of court granting him bail. An FCT High Court in Abuja last week Tuesday dismissed an application by the leader of the indigenous people of Biafra and founder of Radio Biafra, Nnamdi Kanu, for the release of certain items, including his British and Nigeria passports, which are in the custody of the DSS. Apart from the passports, other items which Mr. Kanu, who is currently detained in Kuje prison, wanted released are cash sums of $2,200 and 87,000 naira. Justice James Soho has, however, dismissed the application.
It's too tight, my friend, it's too tight. Can you release it?
A federal high court sitting in Lagos last week Monday renewed its order to all security agencies in Nigeria to compel the attendance in court of former Niger Delta militant Government Ekpemekpolo, popularly known as Tompolo. Justice Ibrahim Buba reiterated the order while ruling on an application challenging the substituted service of a 40-count criminal charge on the accused. The EFCC had filed the 40-count charge against Tompolo, Patrick Apoblikemi, and 8 others. The charge borders on allegations of conversion and theft to the tune of over 34 billion naira.